State of Cannabis.
This is the State of Cannabis News Digest, a roundup of this week's key developments in the cannabis industry.
Before we jump in, this show tracks cannabis policy across the U.S. every week, so you don't have to. If that's useful, tap follow or subscribe now, because the platforms only push shows that get consistent engagement. Your follow, like, or comment is basically our distribution engine. Thanks for being part of it. Let's start. From state capitals to care facilities, medical cannabis policy is entering a new, more practical phase. Less about sweeping legalization, more about who gets access, who pays, and who carries the risk. In Florida, lawmakers moved to sharply cut the price of medical marijuana cards for honorably discharged veterans, a targeted change set against a broader, still-churning cannabis debate. In Kentucky, the friction is federal. Legislators are urging Congress to revisit a decades-old gun law that can put medical cannabis patients in legal jeopardy, even when they're following state rules. Across the Midwest and Plains, the focus is on the machinery of legalization. Missouri's booming market faces a hard look from the state auditor, raising questions about how licenses were awarded, how oversight works, and where constitutionally dedicated revenues are actually going. Nebraska, meanwhile, is trying to get its voter-approved system moving, both by shielding clinicians who recommend cannabis and through a courtroom fight that could shape how future ballot campaigns are policed. And in the places where cannabis meets hospitals, hospices, and assisted living, lawmakers are wrestling with the same basic question. What happens to access when a patient enters regulated care? Oregon advances a bill to build clearer rules for end-of-life and palliative settings. Virginia moves one step closer to protections for staff who handle medical cannabis oil for terminally ill patients, while ordering new statewide guidance. South Dakota debates whether the program still needs a dedicated oversight committee at all. Plus, in Oklahoma, a pair of bills that could keep the state's licensing tight for years, and another that would let counties ask voters whether marijuana sales should help pay for local public services. Stick with us. These are the headlines. The details and the stakes behind them are coming up.
And now here is the deeper look at the key events in the cannabis world this week.
Florida lawmakers are moving to reduce the cost of medical marijuana access for military veterans. House Bill 887, approved unanimously by the House Health and Human Services Committee, would cut the medical marijuana registry identification card fee for honorably discharged veterans from $75 to $15. The reduced rate would apply to initial applications, renewals, and replacement cards, and would take effect July 1, 2026, if signed into law. Florida currently has more than 931,000 registered medical marijuana patients, though the number of veterans in the program is not publicly known. Legislative analysts describe the fiscal impact on the Department of Health as indeterminate, meaning the agency would collect less revenue, but the total loss is unclear. Supporters say the measure may ease financial strain for veterans who use cannabis to address chronic pain, post-traumatic stress disorder, and sleep disturbances, and who may be seeking alternatives to opioid medications. A companion Senate bill, SB 1032, would also lower fees for veterans and proposes broader changes, including expanding physician supply limits and extending required patient evaluations from 30 weeks to 52 weeks. At the same time, Florida's wider cannabis debate continues, with separate proposals addressing recreational legalization, home cultivation, and ballot initiatives for 2026. For now, HB 887 represents a narrower reform, one that could reduce costs for veterans without reshaping the state's overall medical marijuana framework.
Kentucky lawmakers are stepping into a complicated legal debate that sits at the intersection of cannabis policy and gun rights. On February 27th, senators introduced Senate Concurrent Resolution 124. The measure urges Kentucky's congressional delegation to support amending the Federal Gun Control Act of 1968. Under that law, anyone considered an unlawful user of a controlled substance is prohibited from possessing firearms. Because marijuana remains a Schedule I substance under federal law, that restriction applies even to patients using cannabis legally under state programs. Kentucky's own medical cannabis system was created through Senate Bill 47 in 2023 and became effective on January 1st of 2025. Patients now use medical cannabis for conditions such as chronic pain and chemotherapy-related nausea. Yet federal firearm background check forms still require disclosure of marijuana use, regardless of state legality. Lawmakers backing the resolution argue that this creates confusion and legal risk. They say Kentuckians should not have to choose between accessing medical treatment and exercising their Second Amendment rights. The resolution does not change federal law on its own. It formally calls on members of Congress to act. Whether Congress takes up the issue remains to be seen. For now, medical cannabis patients in Kentucky continue to navigate a system where state and federal rules do not fully align.
Missouri's cannabis market has grown fast, and it's brought in serious revenue, but a new audit suggests the state is still catching up on the basics of running it. In February, Missouri State Auditor Scott Fitzpatrick released a report rating the marijuana program as fair. The rating comes with a long list of findings, many of them aimed at the Division of Cannabis Regulation. The audit says the business licensing process had major design flaws and did not consistently apply standards meant to keep scoring fair and anonymous. In the auditor's review, some application scoring contradicted the state's own criteria, and documentation to explain those scoring decisions was often missing. That early chaos had a price tag. The audit summary says Missouri spent more than $12 million on litigation and administrative appeals tied to licensing between 2020 to 2023, with over 1,900 appeals filed. The report also points to problems after licensing, including long delays in approving ownership changes and business updates, and an oversight system that did not prioritize inventory inspections until 2023. For consumers, it raises privacy questions about dispensaries retaining adult-use customer information without consent, and it warns that Missouri's metric tracking system did not identify purchases above legal transaction limits in real time. Then there's the money. The audit says marijuana revenues have not been distributed as the Missouri Constitution requires. It cites large balances sitting in state funds, even though the constitutional amendment calls for equal distributions to veteran services, addiction treatment grants, and the public defender system. The audit notes those programs have communicated the need for more resources, but the funds have not been fully appropriated.
Nebraska's medical cannabis laws are on the books, but patients and advocates say the system still feels stuck. One reason, they argue, is that doctors and other practitioners may be reluctant to recommend cannabis, even after voters approved a medical framework in 2024. A bill now in the legislature, LB 933 from State Senator John Kavanaugh of Omaha, would try to remove that barrier. It would provide immunity for healthcare practitioners, meaning they would not face civil, criminal, or disciplinary action solely for recommending medical cannabis or stating that a patient may benefit from it. Supporters describe it as a narrow fix that mirrors policies in other medical-only cannabis states. At the committee hearing, 5 patients and caregivers testified in favor, and no one testified in opposition. Advocates said the lack of provider testimony may show how cautious the profession is around cannabis. They also told lawmakers they are not aware of any Nebraska providers recommending medical cannabis since the 2024 election, and some patients said they've traveled out of state for recommendations and medicine. Kavanaugh also offered an amendment that would not protect a provider who fails to properly evaluate a patient or who violates the standard of care, an attempt to address concerns that immunity could become too broad. At least 4 members of the 7-person Health and Human Services Committee said they support the bill, and the committee is scheduled to meet Tuesday morning to decide whether to advance it to the full legislature. Kavanaugh has also made LB 933 a priority bill for the year, which could affect how quickly it moves if it clears committee.
In Nebraska, a case tied to the state's 2024 medical cannabis legalization is now playing out in criminal court. J.C. Todd, a notary from York, is facing 24 misdemeanor charges in Hall County. Prosecutors allege that during the 2024 petition drive for Nebraskans for medical marijuana, Todd notarized petition pages when the paid circulator, Michael K. Egbert, was not physically present. Under Nebraska law, notarization requires in-person verification of identity. The investigation began after local election officials flagged irregular signatures, including names of people who had been deceased for years and incorrect birth dates. Egbert later pleaded guilty to a misdemeanor charge of attempting to falsify his circulator's oath and paid a fine. Todd's defense argues that he did witness signatures, but sometimes completed stamps or dates later while managing a busy storefront. He testified that any incorrect dates were accidental. Prosecutors respond that ignorance of notary requirements does not excuse misconduct. The voter-approved medical cannabis measures remain in effect. Still, the outcome of this case could shape how Nebraska handles petition verification and notary compliance in future ballot campaigns. If you're still with us, you're exactly who this show is for. Here's the ask. Follow the podcast if you haven't yet, and if you're on YouTube, hit like. It's not just vanity. Engagement is how the algorithm decides this episode is worth recommending. And if you know one person who would care about medical access, regulation, or cannabis law, share this episode with them. Back to the update.
Oklahoma's medical marijuana licensing system could stay locked down for years under 2 bills that just cleared the State House. House Bill 3143 would extend the state's moratorium on issuing new medical marijuana business licenses until August 1st of 2028. The moratorium already exists and is set to expire on August 1st. Supporters say the pause is aimed at new licenses, while existing businesses in good standing with the Oklahoma Medical Marijuana Authority could keep operating and, according to House debate, open new locations using their existing licenses. The bill summary also adds tighter rules for ownership transfers, including requiring administrative actions or appeals to be resolved before a transfer application can be filed. It also sets a 6-month waiting period after a license annulment, revocation, or suspension before a transfer application can be submitted. House Bill 3144 would cap how many commercial grower licenses OMEMA can issue statewide, with a limit of no more than 2,550 total. Meanwhile, OMEMA currently lists nearly 2,200 licensed growers, along with 686 processors, 1,421 dispensaries, and 58 transporters. The House approved HB 3143 by 82 to 8 and HB 3144 by 82 to 15 votes. Both bills now move to the Senate, where lawmakers will decide what Oklahoma's licensing landscape looks like heading into 2026 and beyond.
Oklahoma could soon give counties a new option to raise money from retail marijuana sales, but it would depend on local voters. House Bill 3314 would authorize counties to impose a public service impact tax of up to 15% on retail marijuana sales within county limits. The bill doesn't create a tax automatically. Instead, it requires a countywide special election, approved by a majority of voters, before anything can be collected. Counties could put the question on the ballot through county commissioners, or residents could initiate it through a petition signed by at least 5% of registered voters. If voters say no, another special election on the same question would be blocked for 6 months. HB 3314 also sets boundaries on how the money can be used. Revenue would go into the county general fund, but would have to be dedicated to specific purposes, including county sheriffs, local police and fire departments, and efforts to improve dilapidated properties. The purpose and duration of the tax would need to be clearly stated for voters, and the duration could be limited or unlimited. The bill also exempts marijuana grown on private property by individuals and not sold. For administration, counties could contract with the Oklahoma Tax Commission to collect and enforce the tax, with a 0.5 percentage point fee, and the Tax Commission would have to give taxpayers at least 60 days' notice of any rate changes. The bill passed the House County and Municipal Government Committee by a 6-0 vote and is now in the Government Oversight Committee. If enacted, it would take effect November 1st of 2026, and the impact would likely differ county by county depending on how voters respond.
Oregon's House has voted to move a bill that targets a specific gap in medical marijuana access. What happens when a patient is seriously ill and living in a care setting that doesn't have clear rules for cannabis use? House Bill 4142, sponsored by Representative Farah Chaichi, passed the Oregon House 39-3 and is headed to the Senate, where the Senate Healthcare Committee is scheduled to take it up on Wednesday. The bill would expand Oregon's definition of a debilitating medical condition to include the need for hospice, palliative care, comfort care, or other symptom management, including comprehensive pain management. It also creates a framework for certain organizations and facilities to be designated as additional caregivers under Oregon's medical marijuana program, including organizations that provide hospice, palliative, or home health care services, and certain residential facilities. If designated, those entities would be required to allow patients or residents to use medical marijuana on the premises. They would also have to create written policies for procurement, storage, administration, and disposal of marijuana and medical cannabinoid products. And they would have to provide educational training for direct care staff on cannabis use, dosing approaches, delivery methods like edibles and extracts, and potential contraindications or drug interactions. The bill does not extend to hospitals, and it exempts hospitals and hospital-affiliated clinics from the policy and training requirements. It would also protect nurses. The Oregon State Board of Nursing would not be allowed to discipline a nurse for discussing the medical use of marijuana with a patient in a patient-provider relationship. If enacted, the bill would become operative on January 1st of 2027, with later deadlines for facilities to finalize policies and make training available.
Virginia's House of Delegates has overwhelmingly approved a bill meant to prevent terminally ill patients from losing access to medical cannabis oil when they move into hospital care or other regulated facilities. On February 24th, the House passed Senate Bill 332, sponsored by Senator Barbara Favola, by a 97-1 vote. The Senate had already passed the bill unanimously, but the House adopted a substitute version, so the measure now returns to the Senate for a concurrence vote. If the Senate agrees, the bill would go to Governor Glenn Youngkin. The bill is narrow. It does not expand who can use medical cannabis. Instead, it focuses on terminally ill patients who already have a valid written certification. As amended, it would explicitly protect employees of hospitals, nursing homes, hospice facilities, and assisted living facilities from prosecution when they store, dispense, or administer medical cannabis oil to those certified patients. SB 332 also directs the Virginia Department of Health to convene a work group to examine how medical cannabis can be safely provided in medical care settings and to develop written guidelines. The work group must include representatives from hospital and healthcare associations, healthcare providers, and hospice professionals. And it is directed to look at federal guidance and how potential changes to cannabis scheduling under the Federal Controlled Substances Act could affect implementation. A report with recommended guidelines is due to key legislative committees by November 1st of this year.
South Dakota's House has voted to eliminate the advisory committee that has been overseeing the state's medical marijuana program since it was built after voters approved medical cannabis in 2020. On Monday, the House passed House Bill 1160 by a 41-26 vote. The bill is sponsored by Representative Tim Goodwin of Rapid City. If it becomes law, it would repeal the state statutes that created the Medical Marijuana Oversight Committee and spelled out how it operates. That oversight committee is currently an 11-member group appointed by the legislature's executive board. It includes 2 senators and 2 representatives, plus non-legislative members from medicine, law enforcement, counseling, and at least 1 qualifying patient. State law requires the committee to meet at least twice a year and make recommendations to the legislature and the Department of Health on topics like patient access, dispensary performance, testing capacity, and regulatory safeguards. Goodwin told lawmakers the committee made sense during the early setup period, but he said it's now an unnecessary layer of bureaucracy. The bill would not end South Dakota's medical marijuana program. The program would continue under the Department of Health, and the state currently has over 18,000 medical marijuana patient cardholders. The push comes amid friction between the Oversight Committee and the medical marijuana industry. In November, the committee approved 11 motions, mostly calling for tighter regulations, without publishing them in advance or taking public comment on each motion. With the bill now moving to the Senate, the next debate may be about whether removing the committee streamlines regulation or whether it removes a dedicated place for patients and other stakeholders to weigh in on how the program is working.
Thanks for listening. This is a listener-powered show in the most practical sense. The platforms only recommend episodes that get engagement. So if you want this podcast to keep growing, please leave a rating, drop a quick comment, and share the episode with someone who would actually use it. Your support helps more people find reliable cannabis policy coverage. Talk soon.